What should you do if you get a partially favorable decision from Social Security? Hi, I'm Jonathan Ginsberg. I'm a Social Security disability attorney. And I'm seeing this more and more where Social Security will approve your case, but they will change the onset date, meaning that instead of, say, being approved as of April of 2015, they'll say you're approved as of November of 2016. Now, what this does, obviously, is it reduces or even possibly eliminates your past due lump sum benefit payment, which obviously is not something that most people are real happy about, especially if they think that their disability actually began many months or even years ago. And I'm seeing this both at the administrative level, where Social Security will approve a case at reconsideration but change the onset date, or at your hearing where the judge will say, I can go ahead and approve your case, but I'm going to change the onset date. And as far as what your options are, you can do a couple of things. One is you can oppose it. You can basically say, no, I'm going to appeal that, and you file an appeal, and you continue on to a hearing or continue on with your hearing to argue that your onset date should be the original claimed onset date. The problem with that is that you could very well end up losing everything. So in other words, if Social Security at the administrative level approves you as of, again, November 2016, let's just say, and you want to be found disabled as of March of 2014, and you appeal the reconsideration decision and you go to a hearing, you can get in front of a judge and the judge could say, sorry, I'm going to find you not disabled at all. That is a risk. And again, with the inconsistency by judges, that definitely could be a potential problem. So you have to be really, really careful about that, because Social Security is not bound by the initial administrative decision approving you at the changed onset date. I think that when people are faced with the situation at a hearing, it's a little bit more difficult, because the judge is basically saying to you, I'm going to go ahead and approve you, and it's hard to sort of turn that down, but I want to change the onset date. And of course, from the attorney's standpoint, that means possibly there will be no fees. Now, from the lawyer's position, that's irrelevant, because we have an obligation to represent our clients zealously, even if that means we're not going to get any fees. So what I would tell my client is, you've got to do what you think is best. Some of the considerations I look at, obviously, are the medical records. And if you have medical records that go back to 2014, let's say, and they're very supportive, then it might be worth fighting this. On the other hand, if there are no medical records going back to that date, and the only thing we have is records from 2015 and 2016 in our example, and those records really reflect treatment in 2015, 2016, it's going to be very difficult to convince a judge that your disability began in 2014. By the same token, if you are turning 50 or 55, the judge may approve you based on the grid rules. And again, the grid rules come into play at age 50 and age 55. So if you turned age 50, let's say, in November of 2016, the judge might say, I'm prepared to approve you based on the grid rules as of your 50th birthday. Hard to oppose that, because again, if you turn that down and you ask the judge to make a decision based on an earlier date, he would have to use a completely different theory of disability. He wouldn't be using the grid rules, he would be looking at functional capacity. And obviously, if a judge says, I'm not convinced about your disability before your 50th birthday or before a certain date, again, very difficult to say to the judge, no, I'm not going to accept that, then risk an unfavorable decision. So again, the options would be to accept the amended onset date and possibly give up past due benefits. The other option would be to reject the amended onset date, continue on with your hearing, and take the risk you could win nothing at all. And by the way, if you turn down Social Security's offer, so to speak, of an amended onset date, you don't get paid. So you have to wait, and this could, again, delay the whole process a year or two. One thing I always tell people to be very careful about is look at your date last insured, because you don't want to accept an onset date that is after your date last insured for Title II disability. If you do that, you won't be eligible for Title II disability at all. So it's really important to know your date last insured, and your attorney should know this. My feeling is, and my experience has been, I can usually kind of spot those cases where the judge might do this. In fact, what I do sometimes is I will ask for a pre-hearing conference with the judge, and just raise the issue and see if the judge is seeing it the same way I am, and so we have an idea of where we're all at. It's very awkward when the judge says, I'm not offering to negotiate, but this is what I'm seeing. What do you think? And then we have to step outside and try to explain to my client in a couple of minutes what's going on. So it's best to sort of be prepared for that ahead of time. So that's what the situation is when the Social Security offers to approve you, but at a later onset date. It's going to cost you hundreds or thousands of dollars in past due benefits. Sometimes it makes sense to accept it. Sometimes it makes sense not to. However, this is a decision that you and your attorney ought to discuss well before the hearing so you know it's coming. No surprises. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook. Any questions, please reach out to me. This is Jonathan Ginsberg. Thank you very much. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.